Hello everyone and welcome to the Fair Credit Reporting Act's Requirements for Employers. I'm Mike Coffey, President of Imperative Information Group. Imperative is a background screening company based in Fort Worth, Texas, and I started it 15 years ago. Oh no, more than that. 15 years ago. And I've been in and around HR throughout most of my career. This year I'm president of the Fort Worth HR Association, the best little SHRM chapter in Texas, and next year I'll be SHRM's district director for North Texas. I'm also a board member for the Texas Association of Business and co-founder of Concerned CRAs, which is a grassroots organization in the background screening industry that's working to improve consumer protection in the area of employment background checks. We are talking today about the Fair Credit Reporting Act and its implications for employers. I assume most of you are aware of the FCRA and its requirements related to employers using employment background checks. What I want to do up front is run a little poll here and see how you gauge your own compliance with the FCRA. So if y'all will take a moment and just answer that poll, it'll help me to just kind of get a gauge where we're at. And some of you are just watching this just so you can get your HRCI webinar credit, and that's fine, and we will be sending that out after the meeting along with links to the slides and the note pages. And actually the note pages are pretty extensive beyond what's on the slide, so you want to make sure if you're interested in this topic or there's something on a slide that piques your interest, you want to go ahead and download those so that you get all those notes. Okay, looks like we're about done. Let's close this and let me share it with you. Here we go. Should pop up here. There you go. And most of you are fairly sure that you're in compliance with the FCRA, and it's really not that hard. But there are a lot of big companies that thought they were in compliance with it and found themselves in class action lawsuits. They settled for millions of dollars. So we'll go through the details. And a few of you know you're not, for sure that you're not compliant, and hopefully we'll give you what you need to do there as well. This is part of an ongoing series of webinars that we do related to background checks. We've got a basic background checks 101 called What Employers Need to Know About Background Checks. And then we've also got a webinar on the EEOC's and Title VII's implications on background checks, and then one on what DOT-governed employers need to know about background checks. So if any of those are of interest to you, I hope you'll go to our website as well. So let's get into the FCRA. Let me hide that. And let's get into the FCRA here. The FCRA is a federal law that was enacted in 1970, and at the time was primarily focused on credit reporting. And when you read some of the language in the FCRA, it's pretty clear that's really what they were initially talking about. But over the years, Congress and regulators and the courts have come to include a lot of non-credit related information that's procured by employers in the definition of consumer report. And we'll get into those definitions. But basically the FCRA covers all information that an employer purchases from a third party, whether it's a background screening firm or a verification service or even an HR consultant, about that company's prospective or current employees, and where they're going to use that information to make an employment-related decision. So let's get into some language first. The first term we need to go over is this term consumer. Really, the Fair Credit Reporting Act should be called the Fair Consumer Reporting Act. Unfortunately, it's not. Ignore the word credit and just think in terms of consumers, and that's just an individual. And in your context as employers, a consumer is an applicant or an employee. Okay, so the term consumer means an individual, just a person. And a consumer reporting agency is basically your background screening company, okay? It's anybody who sells information to employers for a fee. So a credit bureau, a background screening company, companies like The Work Number that provide employment verifications, or companies like the National Student Clearinghouse that provide information about people's college degrees. Those kinds of things are all consumer reporting agencies. What is not a consumer reporting agency are those situations where an employer contacts somebody directly who's directly had experience with that consumer, and they provide information. So for instance, if you're calling to verify someone's employment history and you contact that employer directly and they provide you the information, then that is not a consumer report if they're talking strictly about their own interactions with the consumer. And if you're going to, it makes it a consumer report when you use that information for employment purposes, and that includes, you know, prospective employees that you're considering hiring, but also any other employment-related action, whether you're deciding whether you want to promote somebody or retain them as an employee. Maybe you're doing background checks on an annual basis or biannual basis on your current employee base. Those are all employment purposes as well. And there's a special kind of consumer report called an investigative consumer report, and that's when basically an interview is conducted by that consumer reporting agency, by that third party, and you get into things like that person's character, general reputation, personal characteristics, mode of living, things like that. So if we're doing employment verifications, almost always those turn into investigative consumer reports, because we always ask questions like, was there ever any reason to question this person's integrity or honesty, or did they ever act in a coercive or threatening manner? Questions like that would get into their character, general reputation, things like that. So that would turn it into an investigative consumer report. And this is only really relevant for you in the context of what's got to be on the authorization and disclosure form, and we'll get to that in just a minute. And as I said, if you're talking directly to somebody who's had direct experience with that consumer about their experiences with that consumer, that is not a consumer report. And so it's only when they're talking, when you're talking, you know, when a third party is collecting that information for you, whether it's criminal history, employment verifications, credit reports, and those kinds of things. Now, once you have somebody in your employee, if something comes up and you need to conduct an investigation into the individual's conduct, then and you decide to bring in an outside party to conduct that report, like an investigations company. We do that for our clients, or a lot of companies use their own outside legal counsel to do investigations, sexual harassment investigations, or something like that. Then that is not a consumer report under the law. If you're looking at suspected misconducts or compliance with laws or employer policies. But at the end of that investigation, you do have a responsibility under the FCRA to give a summary of the investigation to the individual if you take some adverse action against them. So if it is a sexual harassment investigation, say, and you go to Bob and say, Bob, we finished our investigation. The investigation was conducted by this outside party, you know, our attorney or whomever, and here's what we found. Then, and based on that, we're going to take this adverse action. We're going to demote you or terminate you or whatever. Then you need to make a summary of the investigation to the individual. Just it's a basic nature and substance of the communication. So, you know, basically, we hired someone to do this investigation. They talked to people who complained of your behavior. They interviewed you, and the information that they provided led us to make this decision. It can be a very brief summary, but that you do need to have to do that. And all the cites for all these laws that are quoted here are in the handouts that we'll make available to you after the webinar. So what are your responsibilities beyond that in the Fair Credit Reporting Act? Well, before you do anything else, when you first have a relationship with the Consumer Reporting Agency, you under the federal law as the employer have to certify that you're the employer, that you have a permissible purpose to access the information that's being provided, that you won't use the information in a discriminatory way or for any other purposes other than those that you've stated. So from time to time, we'll get a call from a client who says that, well, my college-age daughter is now dating somebody who's 10 years older than she, and I'd like to run a background check on them, which is not clearly an employment purpose and is outside of the scope of their agreement, and that wouldn't, under that existing agreement with that employer, that wouldn't be a permissible investigation. And you also have to certify to the background screening company, the Consumer Reporting Agency, that you'll comply with the Fair Credit Reporting Act. And then you'll follow the disclosure requirements in the FCRA. These are all the requirements that we'll get into in just a second. So that's before you ever even order your first background check. You need to do that. The other thing you should do before you ever write your order your first background check is have your policy written on how you're going to comply with the FCRA, how you're going to address Title VII concerns, and how you as a company are going to evaluate criminal history. That's outside of the scope of this webinar, but that's something you should have in place, and we really try to encourage our clients to have them in place before they ever order their first background check. So then you get your account set up with your background screening partner, and before you ever order the first background check, you have to go to that applicant or that employee and disclose to them on a separate document used exclusively for that purpose that you're going to procure a background check. That can't be the small print at the back of your employment application, and that disclosure document can't have any other information on it like a release of liability. That's something I see a fair bit when I'm looking at employers' documentation. They have a release of liability where the applicant says that they release the employer, any former employers or schools, or anybody who provides information to the employer or to the background screening company. Sometimes the background screening companies even give employers forms that say that that the applicant releases the background screening company for any liability. All of those are outside of the requirements of the FCRA and a violation of this requirement that disclosure document be a separate page from the rest of the application and be used exclusively for this purpose. Okay? So I still see employers who don't have those forms set up that way, and so it's really something I want to drive home to you. Then if it's an investigative consumer report, which means if your background screening company is doing employment verifications for you, it probably is an investigative consumer report. You could have specific language on that disclosure document as well that authorizes that you to procure a consumer report, or discloses to them that you're going to procure an investigative consumer report. And that's got to be in writing as well. And these are all the requirements for the investigative consumer report. You've also got to tell them in this disclosure document that they have the right to request the nature and scope of the investigation. It's almost never happens. Very few employers ever do it, or employees or applicants ever request it, but it happens on occasion. Now, some of the language in the FCRA is foggy, so some employers read this section, and if they're going to order a investigative consumer report, they interpret the FCRA to require them to give a copy of the consumer's rights under the FCRA up front when the consumer first fills out this disclosure document. I don't read it that way. and you know, I certainly don't think there's any problem in sharing that summary of the consumer's rights with them up front, except that it's just another 2 or 3 pages of paper to add to your employment application process, and quite honestly, applicants aren't going to read it, and I don't think it's strictly required by the FCRA. But it's the way the language is written, as you can see here. It's hard, you know. It's possible that somebody could read it that way. So here's the language we recommend to clients and suggest that they use. Now, some states have additional language that has to be on there, but this is under the federal law what we require or we suggest our clients use. And again, you'll get the slides and they'll have all of this information. If you have questions, go ahead and ask them throughout the webinar, and I'll answer them all at the end. So that's just the disclosure document language. The next requirement in the FCRA is that you obtain the written authorization of the individual to procure the background check or the consumer report. And that can be combined with the disclosure document. And an electronic signature is acceptable too under the Federal e-Sign Act. And this can be the small print. This authorization can technically be the small print at the back of your employment application. It doesn't have to be on a separate document, but most employers combine the two so that you've got the disclosure language and the authorization on the same document. And the law specifically allows that. That's the only additional information besides the disclosure information and information about the applicant's identity that can be added to the disclosure document would be the authorization. So, but the great thing about putting the authorization language and signature on this single page is the applicant hands it back to you. Now you have signed documentation that this applicant or this employee signed a document authorizing you to do this, but you've also got it as proof that you gave them the disclosure document because they signed it and gave it back to you. So it's a separate document. So that's why we really recommend clients try to combine these things so that they've got them right there. Now, this is a big area of litigation. You hear all these people concerned about the EEOC's focus on background checks and discrimination in the use of criminal history. Well, the last time a plaintiff won a case against an employer for the use of criminal history in a discriminatory way as a violation of Title VII was in 1975. And so as much mileage as some people are getting out of promoting Title VII danger in lawsuits, really the FCRA is a much bigger threat, because a lot of employers aren't doing everything exactly, and plaintiffs' lawyers have figured that out. And these plaintiffs' lawyers are looking for often very technical violations of the FCRA and forcing employers to settle. First America, which runs school buses for school districts all over the country, settled a lawsuit for $5.9 million because they weren't, allegedly, they weren't following the correct authorization process and making those disclosures. And Domino's Pizza just this year settled a lawsuit for $2.5 million because of allegations that they were not complying with the FCRA. In fact, their disclosure document had language in it that released Domino's from liability. And the judge in that case, before it settled, said that on its face he believed that was a violation of the FCRA. So you would definitely want to go back and look at your authorization disclosure document and make sure that that separate page document doesn't have a release of liability. You can have it elsewhere in your application and probably should, but don't have it on that disclosure document. So you get your background check back from your background screening company, and you have to, you see something on the report that may adversely impact the hiring decision. So we've got something that's potentially negative and is going to cause you to, review this applicant more closely and maybe not hire them. Maybe it's going to lead you to offer them a different position. Maybe they've got a 2-year-old DWI and you were going to hire them as an outside salesperson. And you say, you know what, somebody with a DWI, I want to get to know them better before we let them loose in a car on company business. So we're going to offer them a different job. We're going to offer them a job working inside sales, sitting behind the desk and on a phone for 6 months at least, until we get a better feel for them and how they conduct their business, just to protect the company in case it turns out that they are unsafe in their behavior. And so, and maybe how you're going to pay them. Maybe the employment verifications came back and it turns out that somebody doesn't have the amount of experience you assumed that they did, and maybe they didn't falsify anything on the application, just you got more detail from the former employer about their experience and skill level, and you say, well, we're going to offer them less pay than we would have otherwise. That would be an adverse action under the FCRA, and you've got responsibilities under the FCRA before you put those actions into place. The first of those is that you give the consumer, that's the applicant or the employee, a copy of their report and a copy of their rights under the law. And your background screening company will probably be glad to do this on your behalf if you give them the criteria or just request it on a piecemeal basis. A lot of the background screening companies' software systems, including ours, will print the letters and exactly what you need to give the applicant for you. And we do, our system does that at no charge to the employer, and it's everything you need to give the applicant or employee. So, but you've got to do this, give them the full report and their rights under the law. There's nothing in the law that says you have to explain to them why the information on the report may be deemed negative or may have an adverse action. You just got to give them a copy of the report. And this can get you in trouble if you're not doing it. Walt Disney Company had a lawsuit, class action lawsuit filed against them last month. And this is kind of an interesting case because it also goes back to the concept of how important it is that you select a background screening company that is going to do their business right to start with. Walt Disney, according to the plaintiff in this suit, Walt Disney ran a background check on them, and their screening partner incorrectly reported some information about the person's criminal history and reported that they had a conviction when in fact they don't have a conviction. Walt Disney decided not to hire this person, but according to the complaint in the class action lawsuit, did not make these pre-adverse action notices to the consumer. So they didn't get a copy of their report and a copy of their rights under the law. They just told them, based on your background check and your conviction, which they didn't actually have, we're not going to hire you. And so now they're facing a class action lawsuit because, first of all, to add insult to injury, their background screening company made the mistake of reporting a criminal record on somebody who didn't have one. But then beyond that, Walt Disney, according to the allegations, failed to make the notices to the applicant that were required. And then the consumer, once they get a copy of their report and they say, maybe they think this information is wrong, maybe as in the Walt Disney case, they say, this information is not mine. I don't have a criminal conviction. This information is incorrect. Or they, maybe a former employer provides incorrect information, or maybe even a school is unable to verify a degree. And the consumer says, well, that's actually, I did graduate, and here's the proof of it, and they have to go back to the school and or go back to the background screening company and dispute the information. And that's their responsibility. If the consumer wants to argue about the accuracy of the information, they should take that not to the employer, but under federal law, they should take it to the background screening company and dispute the information to the background screening company. And then under federal law, we, the consumer reporting agencies, have 30 days to reinvestigate that information. Now, I can tell you that we close almost all of the disputes we receive, which are very, very few, within hours, usually because we verify that the information we provided is correct. I think we've changed 3, maybe 4 reports in the last 5 or 6 years because of mistakes either on our staff's part or on the part of court records or an employer's records. It should be extremely rare to ever see anything on a report from your background screening company that's not accurate. If you see that very often, I mean, if you see that once a month even, that's way too often, and you've got some real quality issues with your process there. But the applicants should take that to the Consumer Reporting Agency and dispute it, and then, like I said, we've got 30 days to reinvestigate. But a good screening company is going to get that done real fast, because we don't want our clients to lose a good candidate because of an error in the court records or a former employer's records. And we also don't want people in the community talking negatively about our clients or us, for that matter. And so we all try to correct any issues as quickly as possible. Now, like I said, most of the time when we do hear from consumers on the Consumer Reporting Agency side, they're really not disputing the information. They're just mad. They're mad that this former employer is telling people that they were terminated for cause. And even if it's true, it still makes them mad, and they want to vent to somebody. Or maybe they've got a criminal history, and they're mad that the employer found out about it. We hear from applicants pretty regularly who call and say, I've had 3 background checks, and it's never showed this record before, and now you're reporting this information. And then, so our first question is, well, is the information we're reporting, is it correct? Well, yes, but nobody else has ever reported it. So I told the employer I didn't have a record because I didn't think it was going to show up. Well, that's a problem on the applicant side and not answering, truthfully the questions posed to them by the employer. But it goes back to how good those previous background checks were and how thorough they were. So, but they do have 30 days, and even when an applicant does call us and is ugly about it, we kill them with kindness. We bend over backwards to be sweet and lovable, because again, we don't want them in the community talking negatively about our employers or about our company, for that matter. So the other thing is while this dispute is going on, you do not have an obligation under federal law to keep the position open. So if a consumer tells you this information is incorrect, you can tell them, well, you need to contact the background screening company, as is outlined in the summary of rights there that you gave them. But you don't have to hold the position open. Now, if their story seems to have any credibility at all, I recommend to my clients, because I know we do a good job, that they go ahead and hold that position open, because we can close it. We can usually close those disputes within minutes, if not hours. And that way they don't lose a good candidate and have to recreate the wheel of finding another candidate to fill the position. But there's nothing in the law that says you have to hold that position open. But once you decide you're going to fill that position with somebody else or take some other adverse action against this applicant or this employee, maybe it's an employee and you're going to terminate them because they're a driver and you ran your annual background checks and you found out he had a DWI last year. And so it's time, you got to terminate him. He can't be a driver for you. Any of that, once you've made the disclosure to them, a copy of their report and their rights under the law, then you can make the decision. And you have to provide a second notice to them that you are taking the adverse action. You've got to tell them how to contact the Consumer Reporting Agency, and you've got to include a statement under the law that the Consumer Reporting Agency did not make the hiring decision, and that we're unable to discuss with the applicant why the decision was made. And so that's important. Then it also needs to include information about their rights under Section 612 of the FCRA, which is to receive a copy of the consumer report directly from the Consumer Reporting Agency. In other words, they can contact us even after you've given them a copy and come back to us, the background screening company, and say, I want a copy of my report, and everybody who's received it, and we have to share that with them as well. So once you've done that, you're completed. Your obligations under the FCRA have been fulfilled. few other things you need to know about the FCRA. First of all, it limits what employers can be told by the background screening company. So, you know, this is the same law. You're all aware of the fact that things fall off your credit report after 7 years, right? Well, this is the same law, the Fair Credit Reporting Act, and it governs more than just credit reports, as I said. It covers all consumer reports. And so you've got a 7-year limit for a lot of the information that would even be used in the employment context. So there's a couple different things that you need to be aware of. First of all, if the first question is the person going to make more than $75,000 a year? Because if the individual is going to make more than $75,000 a year, then we, the background screening company, can report to you, the employer, anything and everything, unless it's restricted by some state law, and we'll talk about a few of those in a minute. But in general, we can report anything and everything to you if the person's going to make more than $75,000 a year. Now, why $75,000? Well, you got to remember this law was written in 1970, and back then, this was a highly compensated individual. Now, it's your typical management position is in that ballpark. And middle managers or a lot of professionals are making that kind of money. So it's not a lot of money, but the law just has not kept up with the cost of inflation. So so $75,000 is the magic number. And if the individual is going to make less than $75,000 a year, we can tell you about convictions forever. Convictions never go away. Now, again, there are some state statutes that restrict reporting criminal convictions that are over 7 years old, California being most notable. But under federal law, under the FCRA, it's reportable. Criminal convictions are reportable forever, which is why you need to make sure when you're talking to your background screening company that they aren't limiting the reporting of criminal records to only 7 years. Some background screening companies do that because, quite honestly, the rule of thumb in the industry is that as soon as we start reporting criminal records, we're losing money and we're exposing ourselves to risk. And the bigger and sloppier the background screening company, the more likely that they're only going to report stuff within the last 7 years, because it's a lot easier to push a button in a system that says no records found than to abstract and make sure that an actual criminal record that may be 8 or 9 or 10 years old or 15 years old is accurate. So make sure your background screening company is reporting all criminal convictions that they see to you. Now, non-conviction criminal cases, dismissed cases, cases where the individual got deferred adjudication, served probation, and the case was dismissed after they served their probation, even if they pled guilty or no contest, which they have to in most cases in order to be in a deferred adjudication or pretrial diversion program. In those cases, then, those records are only reportable for 7 years after the case has been dismissed. So unless they're going to make more than $75,000 a year. So your applicant may admit to you on the application that they had a theft deferred adjudication case that they served probation on, and the probation was dismissed 8 years ago. If that individual is making less than $75,000 a year, the background screening company cannot report that to you. Even though they've, in a courtroom, admitted responsibility for the offense and served probation, we can't tell you about it if they're going to make less than $75,000 a year. Civil cases, liens and judgments, and credit items, the same thing. They go away after 7 years unless a person's going to make more than $75,000 a year. And then bankruptcy is the one variation to the 7-year rule. That has a 10-year rule on it with the same salary limitations. Texas's only restriction is some states have their own state criminal records limitations on what employers can report, and Texas has one on its books as an example, but it, like a number of other states' laws, were preempted by a change in the federal law a few years ago. And so even though it's still on the books, it's been preempted by federal law, so it's not valid. But some states do have consumer reporting laws that are relevant to you. If you're in Oklahoma, Minnesota, or California, you have to have a little checkbox on your disclosure document that authorizes requires the employer to provide a copy of their report when you get it. So you provide it to the consumer when you get it from the background screening company. And it's your responsibility, not your background screening companies, although I'm sure they would be glad to share, to do that on your behalf if you ask them. That's a requirement in those 3 states. Massachusetts has adopted ban the box. And in Massachusetts, the initial written employment application cannot even inquire about somebody's criminal history. So you can't ask your applicants in Massachusetts about criminal history. And there's other limitations as well as far as what you can consider. They don't really affect the background screening company, except that your background screening company is probably going to work with you to make sure they're not going to feed you information that you don't want to receive so you don't violate the state law in that state. And then there's California. California has special protections for all kinds of people. First of all, employers can't consider any non-conviction criminal information. So if somebody was released from deferred adjudication yesterday, your background screening company, if they're based in California or you're based in California, cannot tell you about that offense. And convictions can only be reported for 7 years. So if somebody was convicted of murder 8 years ago, your background screening company cannot tell you about it. If the applicant lives in California, you live in California, or the background screening company is located in California. They also have under state law protections for marijuana convictions and sex offenders, and there's special language that you've got to have when you're ordering the background check, and there's got to be specific language on the background check itself from your background screening partner. A number of states, at least 10 now, have restrictions on employers' use of credit reports in making employment decisions. Most of them simply require that the employer's review of the credit reports be job-related. So if you're going to make a decision based on a credit report, there's got to be a correlation of some sort between the information on the credit report and the job you're considering the individual for. Now, I talk to employers a lot who say we want to use credit to help avoid theft. They're making the conclusion that because somebody's got a poor credit history, they're more likely to steal from them or have performance issues of some sort. Well, the few studies that are out there do not validate that use of credit reports. There's no correlation has been shown between poor credit history and poor job performance or dishonesty in the workplace. In fact, there's even in the financial industry, a study was done, and it showed that after I think 5 years or more, people with negative credit history who were hired were no more likely to have been in progressive discipline or have terminated voluntarily or involuntarily than the rest of the employee population. So it's probably not something that you want to use willy-nilly. The only time we really recommend clients use credit is when the person's going to be making financial decisions on behalf of the client or the company, and how they manage their own money and their own business may be reflective of how they'll handle the company's money or business. Now, the trick there is there's a lot of things that make people's credit go bad. A spouse loses a job, or the applicant or the spouse gets sick and has some sort of significant illness. Those things all affect people's financial ability to meet their financial obligations, and unless you're really willing to get into those conversations with your applicants about the reasons why their credit may be bad, and then trying to figure out if they're telling you the truth, I really recommend you not even look at credit reports for most positions. That's a little gospel according to Coffey. That's not necessarily the law, but it just makes, it just makes sense for you to think through it. And I mentioned about Massachusetts and ban the box. The box, this idea of ban the box, it's the idea that there's a check box, which most people really don't have on their applications, but a check box where it says check here if you've got a criminal history of some sort, or check here if you've had a felony or whatever. But you've got an inquiry of some sort on your employment application that ask about criminal offenses the person's been a party to. It's illegal in some states now for public and private employers both to inquire about an applicant's criminal history until at least a in-person interview has been conducted. Some states restrict that inquiry by employers until after an offer has been made. So in the notes we'll send you has a list of the states that have those restrictions. Massachusetts, Minnesota, Hawaii, Rhode Island, New Jersey, all have those, and Vermont have those restrictions. There are a lot more states and municipalities that have restrictions on public employers, and there are even municipalities that have restrictions on private employers in those cities. Philadelphia, Pennsylvania, New York, New Jersey, Seattle, all have restrictions at the municipal level on any employer operating inside that city limits and what inquiries they can make related to criminal history. So just be aware of that. And you should be able to talk to your background screening company about both the state and municipal level restrictions, and they should be able to give you some guidance on that. And there we are. Let's answer some questions. We got through a little faster than normal, but let me see here. Got a couple questions here. For reporting of criminal history of candidates, in reporting of criminal history for candidates of employment making over $75,000 annually, does your firm have a space in the background screening entry form to verify salary to determine what or how much to report? And yes, we do. And we're not unique in the industry, but when you're doing when our clients are inputting their background screening request into our system, there's a spot where they can put anticipated salary. It's not a required field, but they can put it in there. Some clients just put 75 plus or less than 75,000, something like that. It's nothing that shows up on the report itself. It just tells our people when we see this report, this information, that we might want to, this is something we need to share with the employer. We can do it legally. And that's the great thing about that. Now, our policy internally is if there's a criminal case that's dismissed, or even a civil case and the employer is asking us to do civil research, and there's something that we think, because of the nature of the employer's business and maybe the position this person has held previously, the employer needs to know about. We'll call the employer and say, hey, is this person going to make more than $75,000 a year? And if they say yes, then we go ahead and report the rest of those items. And then there are also ways where we can do an interview with the applicant, and whatever we talk about with the applicant can be shared directly with the employer. So we find other ways when we really feel like it's important to a specific position or a specific kind of employer to get that information to them. We try and do it as long as we can do it legally. Are there any other questions? Does Imperative Info conduct investigative consumer checks when verifying employment history? Would we need this language? And this is from Courtney, one of our current clients, and yes, we do when we do your either your DOT employment histories or your regular employment verifications. Those are always investigative consumer reports, but if you're using our paperwork, you've already got that language in your form. Our language is pretty specific, but any of our clients and I've got a whole bunch of you on the line today, if any of you have questions specifically, about your form, and maybe you're not using our model form, you're using your own form, feel free to email it to me and I'll be glad to look at it. Let's see, when there is a criminal conviction more than 10 years old that needs further investigation, what is the best way to broach the applicant to start the conversation? Okay, well, it doesn't matter about how old it is, more than 10 years old or whatever. I always suggest that you make the best way to bring it up is to give them a copy of their rights and their report, just like the FCRA says. And you can do this in person if you want to. I mean, you may not want to call the guy convicted of murder, especially if he murdered a human resources manager, into your office to sit down and talk about it. But there may be other offenses where you feel comfortable, especially if it's a candidate that you interviewed that you felt like you should have, the personal follow-up with, and maybe you can invite them in, give them a copy of their report in person and their rights under the law, and then have them go through it and explain to you any information on there. We really try to encourage all of our clients to have a really thorough criminal history question on their employment application, so that all the background check does is verify they told you the truth. And so it basically makes your employment application an integrity test. And if you've got a good question on your employment application, then you really shouldn't have any surprises when the background check comes back. But if you do and you need to share it with them, give them a copy of their report, give them their rights under the law. You can do it by mail. A lot of employers do, or you can invite them in, and then just wait and see if they don't respond back to you. Then you go ahead and make your hiring decision about somebody else. You don't have to solicit them to give, and follow up with them and pester them to come talk to you about it. Quite honestly, let them self-select out of the process if they don't think there's anything in the, to be said beyond what's on the report. Then let them go ahead and just opt out of the process by not responding. You go ahead and make your hiring decision and go to your next candidate. Let me see here. If we receive a clean MVR but are assigning points based on a vehicle accident an employee was involved in, are we required to send the pre-adverse action letter? Okay, yes. So this is one of our clients, and they pull driving records on all their employees on a regular basis because they have a lot of drivers. And they have a system where if you've had certain infractions on your driving history, those infractions go to a point system, and you can't be employed as a driver if you get so many points in a certain period of time. That's straightforward enough. So the question is since this is an obvious black and white rule, and the information is coming directly from the state on the driving record, do we still have to follow all this FCRA stuff, the pre-adverse and adverse action notices? And my answer is yes. I would say before you apply those points to the individual's tally system, or however whatever you call that, where you keep those points, you go ahead and give them a copy of the MVR, or the whole report that came from the background screening company, and the copy of their rights. And they receive that, then you go ahead and add the points to the system. And if it's enough points and they ultimately are terminated, you tell them we're terminating you based in whole or part on this report, and and total of your points according to our policy. Let me see here. Now, if there's something, let me say this: there could be something that on its face seems negative on the report, or even a driving record, like maybe they got a ticket, but maybe you don't care about one ticket, and it's not going to result in any kind of adverse action against the employee. Do you have to, in those cases, make those adverse action notices to the employee? And the answer is no. If the information on the report isn't going to lead to you making an adverse employment decision, in whole or part based on that report, then there's no reason to give them a copy of the report and their rights under the law. Only if it's going to result in an adverse action. Let's see what else we got here. can you briefly describe the requirements of complying with the federal e-signature guidelines? Now that's a little tricky because there's some really technical stuff there. But basically you've got to have certain data fields captured. It's got to capture, if I remember right off the top of my head, we haven't looked at this in a while, but e-sign requires that I think you capture exactly what they are certifying or signing, that they have an explicit process where they sign it, and it can be a mouse click signature where they click, or they use the mouse to write their name, or they type their name, or maybe their social security number, some information, some identifying information of some sort to do a signature, and it's got to be recordable and traceable, and all of that. Your technology people are probably better qualified than I am to get into the details of that, or I'm sure there's a ton of consultants out there with stuff on their websites about e-signatures. Ours was kind of one of those things you program once and then you forget all the details, and we've got a great set of programmers who manage all those kinds of things for us. Let me see here. Is there anything else? Okay, I answered that one. What are your recommendations for dishonesty on an employment application? Specifically, an applicant does not disclose a pending charge or deferred adjudication on an application, and the background report reveals a criminal history in this regard. Well, it's only dishonest if you asked a good question. If you only asked about convictions on your employment application, which I see a lot of employment applications that only ask about criminal, felony convictions, and maybe in a limited number of years, I think those are ridiculous questions. What's a felony in Texas could be a misdemeanor in Oklahoma, and you really don't care about how the law categorizes the offense. What you care about as an employer is the conduct the person was alleged to have engaged in, and you got to decide if that conduct that happened so long ago or fairly recently is relevant to the position for which the person is being considered. So the first thing is to have a good employment application, and if you go back to my ban the box inquiry slide when you get the slides, that's the question we give our clients to ask, and feel free to email me, and I'll share that with you as well. But the first step is to have a really good inquiry on the employment application, because a lot of people just ask about convictions. But you mentioned deferred adjudication or pending cases. Make sure you include those in your inquiry. But if you find out they did have a deferred adjudication case, and maybe they're on probation now, or it was dismissed within the last several years, that is and they didn't tell you about it, and you asked about it directly, my answer is universally, if it's legal for you in your state to consider that, and it is in most states, then I would say that the individual lied on their employment application, they falsified their employment application, and I would eliminate them in our organization for falsifying their employment application, just like any other bit of dishonesty in the process. Like I say, this is the least expensive integrity test you will ever give this person. And it doesn't mean the person, because they lied about their criminal history in the past, means they're going to steal from you or commit some bad act, but it does mean that they lied on the application, and you can evaluate that as an employer and say, we don't tolerate dishonesty in our organization, and we're not going to let you come into the organization with a lie, in our initial interaction. Somebody says, I had a candidate who had an outstanding warrant in another state that was more than 15 years old. Let me look at that. I lost here it is. Can that information be used to make a determination? Well, I would suggest that it would depend on what the warrant was for. If the warrant was for a traffic violation that's 15 years old, it's possible that applicant wasn't even aware of it. But depending on, if there's an active warrant on it, at the minimum, I would require the applicant to clean the warrant up before you considered them for employment. And I certainly, if they had an active warrant, would not hire them until they'd taken care of that. That's just, you want your employees to be available for employment, which means you don't want them going to jail when they get pulled over for a traffic ticket on the way to work and not be there. So I think it's certainly reasonable to say, before we even discuss anything else, here's a copy of your report, here's a copy of your rights under the law, and you need to, before we make a final determination about your eligibility for employment, you need to take care of this warrant. There's nothing wrong with that. Now, I would make sure they took care of a traffic ticket, but if it was something more severe, theft or some sort of assault or something where we had a case recently where somebody was a prison guard in Florida, and they were applying to work at in the oil field up in Nebraska, and for one of our clients up there, and we found they were in fact a corrections facility employee in Florida. But we also found that they were wanted, that they had warrants for felony warrants for their arrest out of Florida because of official misconduct as a security guard or as a prison guard. Apparently, they were extracting bribes out of prisoners' families and things like that. And so it was one of those things where the warrant was several years old, and apparently Florida hadn't been able to find them. And here they are working in a whole other state, in another part of the country. And ultimately Florida contacted us and said, "Where is this guy? We really want them." And we helped them coordinate with local law enforcement to pick the person up. So yeah, I would be concerned about a warrant, and it needs to either be cleaned up or they wouldn't be eligible to work any place that I was in charge of. In California, are there specific restrictions for which candidates a credit check can be run at that are not at the manager level? Yes, I believe, and I'd have to go back and look at the California law specifically because there's so many laws and this is changing a lot, but I believe California has a fairly strict rule that says that the use of credit has to be job related. I don't think you're one of our clients, but check with your background screening company or shoot me an email, and I'd be glad to look up my understanding of look at my resources to see exactly what the California limitations are. But I believe the requirement is that it be job related, and that you probably held pretty closely to that. So you'd have to have your rationale, and I would really recommend you have your rationale in place before you ever ordered it. Can credit reports be considered for positions where the employee will have access to employee data, which could be used for identity theft, such as an HR position? It can be. I'm not sure that the correlation is there, that it's going to tell you what you think it's going to tell you. Again, the assumption you're making there, the underlying assumption from your question, I think, is that somebody with bad credit is more likely to steal from you than somebody with good credit. And I don't know that that's true or not. I mean, certainly I'd love to sell you, this happens to be Kelly and one of our clients, and I'd love to sell you more credit reports, but to be honest, I'm not sure that they tell you the story you think they tell you. So I'd really want to try and visit with you more to see if what you really want to learn from the credit report and what your process would be for vetting it. Certainly it's legal, and I wouldn't be worried about using it and getting sued for discrimination under Title VII, and I've got a whole webinar on Title VII issues, and I wouldn't be that concerned about that. My concern is just, is this really a good tool to use? Is it really going to tell you what you think? And we could go back and forth, and maybe you might decide you're going to go ahead and run credit reports on those individuals, and then look at it over a year and see if there was anything that really turned out to be a significant red flag for you. Because one thing you don't get with an employment credit report is a score. So you see that they've got a 500 or 600 or 750 or whatever. You only see their payment history, their trade lines, and collection accounts. And so those are kind of hard to fairly evaluate and compare from person to person because the circumstances will be so different. But I'd be glad to talk to you about it if you have any questions. Let's see. What is your opinion of action to take regarding candidates who respond no to the background screening question? I think that's about the criminal history question. And I think I probably answered that one already. If somebody tells you they don't have a criminal history and you come find out that they do, and that it's something that they should have told you about according to the question you asked on the employment application, then I would suggest that you probably really want to consider carefully whether see what your policy says about falsifying the application and apply it. And sometimes the applicants do say they don't understand the question. Well, the next question there is look at your question, and if it's an obvious, if it's clear, if it's an obvious question, and they say they didn't understand it, I'd say, well, that's the question we ask, and if it does seem like a fair question and it's not tricky, then the real question is they didn't understand it. Well, do you really want somebody working for you who can't understand a standard straightforward question? And whether they understood it or not is not really the issue. It's what they responded. And my response would be, well, if you didn't understand it, you should have asked us about it because it's right there on the employment application. The webinar number will be shared. We'll be emailing that out to everybody via email later this afternoon. And that's our last question. So let me ask one last thing of you who are sticking around. I just want to know, did you learn something today that'll change your practices? I'm kind of always curious if I'm adding any value to anybody's process with what we're doing. And half of you have voted and said yes. Well, that's very flattering. Good. Well, I really appreciate that. 60%, 61%. Okay, good. Wow, it's almost all of you voted. Let me see who else is here. Okay, I'm going to go ahead and close that poll and share it just so you can see. And everybody who responded said yes, they did learn something that's going to lead them to maybe review some practices in their organization, which is great. That's why we do this. These are free webinars, but it's just our way of trying to be a service to the HR community and certainly our clients. And hopefully some of you just don't love your background screening company. Maybe you're just not I hope our clients love us. That's our goal. And if you're not in love with your background screening company and they don't, maybe they cause more work than you feel like they should for you, or you have to do investigation yourself, or when you have a question you can't get hold of anybody with a good answer, maybe we would be a better fit for you. And if so, I would love to talk to you. Don't hesitate to call me. If I'm not here, Andrew in my office handles all of those things for me when I'm out of the office. And we'd love to talk to you if your background screening process isn't working well for you. Also, we've got these other webinars, and they're all free as well. And we haven't scheduled, this is the last one for 2013, and we haven't scheduled 2014. We'll get it out in the next week or so, hopefully, and it'll be up on the website. And if there's anything I can ever do, and if you're in a SHRM chapter anywhere, I speak to SHRM chapters several times a month all over the place, and I would love to come talk to you, to your SHRM chapter or your HR group about any of the things. We've got probably a dozen topics that I speak on to SHRM chapters, and it's all on our website. Thanks a lot. Oh, well, I'm going to stick around. It looks like we've got a question here that just came up. Let me, I don't mind answering it while we're here. Specifically, we intend to implement direct counseling of background reports with candidates, at least on specific cases involving highly compensated jobs. So you're talking about having a process in place, I think, where you visit with the individual personally about any issues on their credit report, not their credit report or their background check, and I recommend that. I think, especially C-level or professional positions, you want to do that. And if you've got the time, it can't hurt to do it with all your applicants. In my frontline HR world and in all the consulting I've done, I really strongly believe that the less uncertainty there is out there about why somebody didn't get a job or their status as a candidate, the better off the employer is. Because the more people say, I applied at that place and they weren't fair with me, or the more that they're left to assume why you didn't hire them. And it always goes to, you didn't hire them because it was an unfair decision based on their age, race, sex, national origin, religion, whatever. And do you really want to give people that latitude to make those assumptions? Why not have a frank conversation with them about your company policies? Because if you've got the policy, clearly you're willing to defend it. So why not have a real frank conversation with them about the policy and how it affected the decision? I just don't think hiding the ball from candidates is your best bet. And we will be emailing the HRCI information to everyone who attended later on this afternoon. So I appreciate all of you sticking around with us and joining us. I hope you all have a wonderful holiday season, whether your end-of-year holiday has passed or you've got something coming up for Christmas, or maybe you're in the middle of Hanukkah. Whatever's going on, I hope that it's all well, and that you have a wonderful 2014. Everybody take care. Thanks a lot.